Today, we are discussing a very important but rarely explained topic. What do judges actually look for while hearing arguments from plaintiffs and defendants? This video is extremely useful for litigants, young advocates, law students, and even experienced practitioners. Because cases are not decided on emotions or loud arguments, but on judicial expectations. Welcome to my YouTube channel, Legal Information Law Insights. I am Advocate Mukund Mahajan. Let us understand this topic from a judge's point of view, in a clear and practical manner. 1. Clarity of facts, the backbone of every case. The first thing a judge looks for is clarity of facts. Judges handle hundreds of cases. They do not have time to decode confusing stories. They expect facts to be simple, chronological, logical, and consistent. From the plaintiff. Facts must clearly show how the right is violated. Each fact must support the relief claimed. No exaggeration or unnecessary emotional narration. From the defendant. Clear admissions or specific denials. No vague or evasive replies. Judicial reality. If facts are unclear, even the strongest legal argument fails. 2. Honesty and fairness, the foundation of credibility. Judges are highly experienced. They can easily identify suppression of facts, half-truths, and misleading submissions. Judges deeply appreciate lawyers who admit weak points honestly, disclose adverse documents, do not mislead the court. Once credibility is lost, every argument is viewed with suspicion. Courts respect fairness more than cleverness. 3. Pleadings decide the limits of arguments. Judges are strictly bound by pleadings. Before hearing arguments, judges carefully examine plaint, written statement, rejoinder, and affidavits. They ask, is this argument supported by pleadings? Is there a factual foundation? Golden rule of litigation. No pleading, no proof, no argument, no relief. Even a legally valid argument fails if it is not pleaded. 4. Relevance over length. Courts value precision. Judges are not impressed by long speeches, repetition, and irrelevant case laws. They prefer short, focused submissions, direct answers, and arguments strictly related to the dispute. Judicial preference. 10 relevant minutes are more valuable than 2 hours of unfocused arguments. 5. Issue-based arguments. How judges actually decide cases. Cases are decided issue-wise, not emotionally or narratively. Judges expect arguments linked to each framed issue, evidence connected to those issues, legal provisions applied issue-wise. Wrong approach. Overall, my client deserves justice. Correct approach. On issue number 1 regarding ownership. Judges write judgments issue-wise, arguments must follow the same path. 6. Correct law and relevant case laws. Judges do not expect memorization. They expect accuracy and relevance. Judges look for correct statutory provisions, latest legal position, judgments with similar facts. They carefully examine applicability, ratio of the judgment, factual similarity. Quality of case law matters, not quantity. 7. Consistency of stand. Stability builds trust. Judges closely observe whether a party changes versions, takes contradictory stands, and shifts arguments at different stages. They compare pleadings, evidence, cross-examination, and final arguments. Inconsistency weakens even a truthful case. 8. Evidence, not emotion. Law prevails over sympathy. Courts are courts of law, not sympathy forums. Judges decide cases on documents, oral evidence, exhibits, and legal proof. Not on personal suffering alone, emotional appeals, and allegations without proof. Every claim must be supported by evidence. 9. Courtroom conduct, quietly observed, deeply noted. Judges constantly observe tone and demeanor, respect towards court, conduct towards opposite counsel. They dislike aggression, arrogance, and personal attacks. They appreciate calm advocacy, professional courtesy, and respectful submissions. Good conduct silently strengthens arguments. 10. Practical and enforceable relief. At the end, judges ask, is the relief lawful? Is it practical? And can it be enforced? Judges discourage vague prayers, impossible reliefs, and reliefs beyond jurisdiction. Courts grant realistic justice, not hypothetical relief. 11. Assistance to the court at the highest expectation. Judges see advocates as officers of the court. They value lawyers who assist in understanding facts, simplify legal issues, help reach a just conclusion. Judges do not appreciate showmanship, intimidation, dominating behavior. The best advocates are those who help the court decide correctly. Final judicial insight. Judges look for clear facts, honest pleadings, consistent stand, relevant law, evidence-backed arguments, dignified courtroom conduct. Justice flows where truth is presented with clarity and dignity. Thanks for watching this video. If you found it informative, please like, subscribe, and share your thoughts in the comments. Don't forget to hit the bell icon for more legal insights. I will meet you in the next video soon. Jai Hind. Jai Bharat.